Are you a parent of a child with special needs and that child's about to turn 18 and you're considering guardianship? I'm AttorneyFilis with the Filis Law Firm, where we focus on helping families with children with special needs. Today we're going to talk about a physician's certificate of medical examination. This is one of the forms in Texas that you have to have your doctor fill out and submit to the court as medical evidence. Your child's doctor will fill out Section 1 with their information and check yes that they are a physician currently licensed to practice in the state of Texas. The proposed ward is your child, so your doctor's office will complete this area and state the date on which they examined your child and where. Now, the date when they examine your child is important because in some cases, the examination date cannot be more than 4 months prior to the application date of the guardianship. Now, when you're thinking about filing for guardianship of your child, your attorney can file the guardianship application as early as 6 months prior to your child's 18th birthday. You can't have the final hearing until after your child's turned 18, but you can definitely get the case started as early as 6 months before the 18th birthday. In Section 2, if your child has a physical condition, your doctor will fill this out. For some of us, Section 3 is more important, where we're discussing mental functioning. For example, with autism spectrum disorder, number 3, mental diagnosis would be ASD, and the doctor will indicate the severity, the prognosis, and then the treatment or medical history. I've seen for treatment, especially for autism spectrum disorder, the ABA therapy and special education services at school. Now, for some of you, in addition to autism, there is a lower IQ than average, and so there's a diagnosis of intellectual and developmental disability. So that IDD should be indicated in number 3 under mental diagnosis. Under 3C, most likely your doctor's going to skip this section because it deals with dementia. Possibility for improvement. In most cases, there's no possibility for improvement. Page 2. Cognitive deficits. Your doctor's going to indicate whether your child is oriented to person, time, place, and or situation. And in Section 4B, your doctor's going to check off which of these areas your child has a deficit. Recognizing familiar objects and persons, reasoning logically, interpreting idiomatic expressions or proverbs. Now, number 5 is specifically important because these describe the rights that you're going to ask the court to take away from your child. For example, can your child initiate and make responsible decisions about managing their personal bank account, safely operating a motor vehicle? How about determining where your child's going to live? Now, typically what I see is that most of these answers are no. Sometimes, especially right here, attend to basic activities of daily living with support and services. So can your child bathe and groom themselves with your help? If yes, that's okay. Number 6 is about developmental disability. And so one of the issues that I see is that we'll have doctors that will check off autism, but not intellectual disability, even though they've indicated that there's an intellectual disability elsewhere in the certificate. So let's make sure before you file this in the court that all of the disabilities are marked. Page 3 is very important. If your child has an IDD, your doctor should definitely complete the content that's in this box. So either your doctor is making an examination right then and there at the date of this examination, regarding your child's intellectual or IQ level, or they're updating or endorsing a prior determination. If you have medical paperwork where an IQ test was performed and you have the results, share that with your doctor so they can click on this box and then endorse the prior determination of IDD. Your doctor will also, if they're saying that there is a determination of intellectual disability, they will need to assess what is the level. Number 8 is very important. We have to have, in order to file for guardianship, there needs to be medical evidence that your child is incapacitated based on the legal definition in the Texas Estates Code. Your doctor is also going to indicate whether or not the incapacity is total or partial. There are options with the type of guardianship that you'll file. If your doctor has indicated there's total incapacity, then you'll file a regular permanent guardianship. If there is the possibility that your child can make certain decisions on their own, then a partial guardianship is warranted. Please note, though, that there is a strong push for lesser restrictive alternatives to guardianship to be considered before a court orders a guardianship. So if your child has the capacity to do some, but not all of the tasks necessary to care for themselves or to manage their property, then the court may wonder and may inquire about the use of a power of attorney or medical power of attorney instead of having a partial guardianship. Page 4. There's an evaluation of the capacity. Now, this section right here on page 4 is about section 5. So when you go back to section 5, if your doctor had indicated yes anywhere here, so let's say attend to basic activities of daily living with supports and services, then your doctor's going to have to answer this third question. If your doctor indicated no to everything and also said that they believe your child is totally incapacitated, then they don't have to answer anything on this top part of page 4. Number 9, should your child would they be able to attend, understand, and participate at a hearing for the guardianship? Your doctor's going to indicate yes or no. So let's say they indicate no. And the second part says, because of your child's incapacities, I, the doctor, recommend that the proposed board does not appear in court. Then they would indicate yes. And then if there's any medication that your child takes that may affect their demeanor, that would be indicated here as yes. Number 10, most of the time doctors will indicate that the best place or most appropriate place for the proposed board is at their home. And then their signature, all of this information needs to be filled out, including their license number. A clean copy or scan of this document can be e-filed with the court. So please make sure if you are emailing this form to your attorney for e-filing that it's a high-resolution scanner that you're using. If you have any questions, we're happy to answer you. 713-462-177, Filis Law Firm. Thank you much.